Good afternoon, and welcome to the JPC and our webinar. I am Shoshana Bryan, Senior Director of the JPC and your host. Our guest today is Ilya Shapiro, Senior Fellow and Director of Constitutional Studies at the Manhattan Institute and JPC Fellow. I said this the last time he was with us, which was in May. Ilya is here, A, because he's terrific, and B, because I am confused. I was confused then, I am confused now. So I was planning to use this session to promote his book, Lawless, The Miseducation of America's Elites, and I'm still going to do that. My full review is in the upcoming issue of In Focus Quarterly, the winter issue. But in short, this is a book you need to read. I called it scary depressing. Grammarly said I couldn't say scary depressing, but I said it anyhow. The path our law schools have taken has worked to restrict who enters, how they study, what they learned, how programmed they are when they come out, and they did it all deliberately. So we are going to talk about Lawless, but we also have another issue that has come up since Ilya was here last time. Everybody thinks they're a judge. We're used to a flood of opinions. There are people with experience, people with no experience, people who have a political axe to grind, people who know a little bit about American law, people who know nothing about American law, people want to make American law by themselves. All of this has been going on, and increasingly you hear it in relation to immigration visas and deportation policies, among other things. But now we're seeing something else, and that is judges who not only opine, but make their own laws. And it seems to me that they're creating a disconnect among the three branches of government. So I need an expert. You need an expert. We need Ilya Shapiro. But first, your JPC commercial. I'll do the short version today. The JPC was established in 1985. You can find us on our website, jewishpolicycenter.org. There you can see our insight articles, our magazine in focus. Fall issue is up now. Winter issue is coming shortly after the first of the year. Take a look at our newly revised In Context section as well. Blogs, updates, and posts from Israel. There's a lot of good stuff there, as well as our webinar programming, jewishpolicycenter.org. The JPC supports a strong American defense capability, U.S.-Israel security cooperation, and missile defense. And as it has been since October 7th, our primary job right now, we think, is to support the government of Israel and the IDF in their defense of the people of Israel and the borders, and over the borders, ensuring that Hamas has neither military capability nor governing power in Gaza, and securing the release of the last hostage, Ron Gvili. The hostage tag stays until Ron Gvili gets home. And we support American support for Israel. Domestically, the JPC advocates for small government, low taxes, free trade, fiscal responsibility, energy security, free speech, and intellectual diversity. Those last two are the reasons that Ilya Shapiro is a JPC Fellow. He is, as I mentioned, Senior Fellow and Director of Constitutional Studies at the Manhattan Institute. Previously, he was Executive Director and Senior Lecturer at the Georgetown University School Center for the Constitution, which is the starting point for Lawless. And before that, he was Vice President of the Cato Institute. Aside from Lawless, Ilya is the issue of supreme disorder, judicial nominations, and the politics of America's highest court. It was also reviewed in Focus. He is the editor of 11 volumes of the Cato Supreme Court Review. You can also read Shapiro's Gavel, the newsletter that Ilya writes on Substacks, and I think you should read it. I learned a lot about the importance of macaroni and cheese to the Thanksgiving dinner table. But seriously, you learn a lot. You learn where judges are, where lawyers are, where people are, where the executive branch is. It's a really great, especially if you're not a lawyer, and I'm not, it's an especially great way to keep up with things. He holds degrees from Princeton University, the London School of Economics, and the University of Chicago Law School. You can ask him questions. You can ask him how he feels about those institutions today. So Ilya Shapiro, the floor is about to be yours, but I would ask you to start with the basic point of Lawless, the miseducation of America's elites, and specifically, what is the damage that this sort of thing does to the American legal system now and in the future? Now the floor is yours.
Well, Shoshana, thanks for having me again, and thanks for doing a second round of book promotion. That's very generous. If you want the fuller version, that was in May, as you mentioned. It's available in the video archives on the website. Um, so this book emerged from my so-called lived experience with Georgetown Law, as you said. The center that's for the Constitution, that's all the more important because we learned that the greater law school is a center against the law school, against the Constitution. And it really presents an indictment of the state of higher education, specifically legal education, law schools, which is particularly upsetting or concerning because, however bad it is when a sociology or English department goes off the rails, let alone those area studies departments that aren't really interested in academic pursuits in the first place, they that is a human failure. That's a waste of money and resources, and filling young minds with mush. But there's a much more direct and practical harm from the perversion or the illiberal takeover of law schools, and that is that these institutions generate the next generation of leaders of our gatekeepers of our political and legal institutions. So if we care about the pillars on which American democracy, prosperity, you name it, rests, those are undermined in a way that's much different than the decades old battles between left and right or different interpretive theories of the Constitution or jurisprudence. The, these are failures of ideology, leadership, and bureaucracy. Ideology, everyone's aware of those fights, the critical legal studies, the critical race theory, all of these kind of postmodern theories that question the legitimacy of all existing institutions, systems of law, governing structures, what have you. Not just this policy should be moving a little more to the left or what have you, but the whole system is illegitimate because of baked in inherent power imbalances as between racial groups, as between the privileged and the underprivileged, as between the oppressor and oppressed, according to an ever shifting ranking of privilege or a matrix of intersectionality, these different identity categories. And so everything needs to be blown up or burned down and rebuilt according to a different basis, a different power structure, things like that. That's really dangerous, to say the least. So that's the ideological part. The bureaucratic part is that people don't realize that you talk about DEI structures and offices, and yes, that's been a huge problem and the explosive growth in that sector in the last decade. But more broadly, non-teaching staff, bureaucrats or educrats, as I call them, have grown precipitously in the last quarter century or so. I graduated college about what is it now, 26 years ago, law school 22 years ago. But it's really been in that time where whatever's wrong with the faculty, which is plenty, that's an issue in and of itself, going back to the ideology. The non-teaching staff, whether you talk about the DEI office, but also the admissions office, putting a thumb on the scale for activists rather than scholars, or those who want to blow up the system rather than those who want to be prosecutors or defense lawyers or antitrust partners making for better consumer prices, what have you. The bureaucracy has really been, the tail that wags the dog, such as the deans and presidents of elite schools cower in the face of what their vice president or vice dean for DEI or all these other kinds of programs is telling them. And these non-faculty officials are the ones who are putting in place the culture of the institution. uh, orientation programs for freshmen or 1Ls, periodic programs on how to view the world, how to make the most of your life, of your career, of your academic program that you're in. The faculty, who again are very problematic, and there's very few non-progressives. The left doesn't know what the far left is doing half the time, but there's sometimes tokens of the right, whether it's conservative, libertarian, or what have you. But these are all very left-wing institutions. But the bureaucrats who put the faculty have they say we don't want to do these bureaucratic tasks, and so that's allowed these important parts of the institutions to grow. And the statistics, which I detail in my book, are mind-boggling. The joke is 100 years ago, Yale students came to campus with their own personal butlers. And now, given the number of these educrats, we can just maybe that's what the goal is eventually, to provide each student with an educrat to hold their hands as they go through this very anxiety-ridden process of trying to learn something, or maybe not, because learning something or trying to gain expertise is a trope of white supremacy or what have you. So that's the bureaucracy, and then leadership. I alluded to this. Deans and presidents, provosts, they themselves are generally not woke radicals or social justice warriors. They're careerist bureaucrats who have been successful at climbing the greasy pole of academic leadership. They're generally spineless cowards that they're amoral. They defer to placate these illiberal mobs that they've allowed to take over their institutions. And so these failures upon failures have created a vicious cycle that to change anything, we really require external pressures and exogenous shocks, whether from state legislatures with respect to public schools, alumni and trustees, congressional investigations, and now, of course, we've had this year executive branch action.
So it seems to me that the response to all of this, and you talk about this in the book, we're always going to go back to the book. I mean, listeners, we're going to go to the book a lot.
Lawless, can't say the name enough.
Lawless, the miseducation of America's leaders.
Not to be confused with another book of that name published by someone who, with a radically different ideology, is also a law professor. It's kind of ironic, or at least amusing, that we published the books by the same title within a few months of each other.
Ooh, scary. Okay, but in the book, one of the results of this bureaucratic uprising or rising up, and the administrators not being willing to take it on, is that you end up with a culture in which students don't argue their points and professors don't argue their points. I always thought of lawyers, and I admit I'm old, so it goes back a long way. Lawyers putting forward two positions and they argue them and they put the evidence out there, and the judge or the jury then makes a decision. But you're really talking about people who are afraid to argue, because if they argue, they get in trouble. And if you're a student and you get in trouble, that could impact your career for the long term. So at the student level, it seems to me that you're changing an argument over the law and the application of law to don't hit me. And in
Huh.
your case, it's not only happening to students. You published something that said, no, you can't publish that. And because they didn't want you to say what you said, you got in all kinds of trouble. So, first of all, question, is it true that the ability to argue or the determination that that's what you should do is disappearing? And secondly, you want to tell us how it happened in your case?
Yeah, so it used to be, um, I'm not old enough to directly remember the paper chase that came out before I was born, the movie, where there's this very old school professor in a three-piece suit at Harvard Law School who uses the Socratic method, asking questions of students to get towards whatever the knowledge that needs to be conveyed. And it's all very intimidating. It's all very, there's lots of wood and chalkboards. It's, from a different age. Um, there's still some of that when I was in law school. University of Chicago is where I went, and we still have some Socratic method. And we were late adopters on Wi-Fi as well. I think during while I was in school there, we were wired internet, but we didn't quite have Wi-Fi yet. Now it's all a little different. But the that kind of rigor has disappeared. And the idea that you would cold call on students and put them on the spot, that can be triggering, especially with some fraught concepts that need to be discussed in law schools. And I'm not just talking about politically controversial constitutional issues or civil rights law, but in the criminal law, the law of rape is not taught in many places because that can be triggering or make people feel unsafe. Let alone those other areas of civil rights that touch on identity categories where, certain topics, certain perspectives are outside the so-called academic Overton window, the permissible range of policy views. Never mind that, Justice Scalia might have been right about something. Never mind that, Justice Thomas wrote the majority opinion of something. We can't discuss them because that's makes you feel quote unquote unsafe. By the way, that's the migration of certain social psychology, behavioral, cognitive psychology, insight, safetyism that really goes against and prevents the intellectual search in schools. But in law schools, where you're the most effective lawyers understand all sides of a particular issue to be able to advocate for their client, whether that's in court, in a business negotiation, or whatever it might be. If half or more of those perspectives are forbidden, you're simply going to be a less effective lawyer. So just in the very basic, non-ideological goal of training good lawyers, law schools are failing because you can't say that, you can't think that, you can't investigate that. Um, in constitutional law, we have the interpretive theory of originalism, the basic idea that at one point didn't have a name because it simply was constitutional interpretation, that you understand provisions to mean what they meant, what their original public meaning was at the time of enactment or ratification. Uh, a lot of law schools in this country don't have anyone teaching an originalist perspective. I don't mean originalists themselves. Again, there are very few conservatives, libertarians, or what have you. But even a good faith, old school ACLU liberal type who'd be able to convey this is the method, and if you want to be an effective lawyer for, half of the judges on the federal judiciary are sympathetic to originalism. Here are the tools for that. They simply don't have it, and so they're failing in their basic missions. Now, what happened to me is a parallel to this. It wasn't something that I was teaching or trying to teach to class. I didn't get into the classroom. I was suspended 3 days, 4 days before I was even joined the faculty because that was when I tweeted out my criticism of President Biden for limiting his search for a Supreme Court nominee by race and sex. I said it in a way that wasn't the most, it was inartful, I characterized it as. And were it not a Twitter hot take, were it an op-ed or something like that, I would have put it a different way. But it was what it was. And there was this 4 days of hell where it was unclear whether the entire career that I'd worked for decades to build would crumble, whether I'd have this job, whether I'd, support my family. Followed by 4 months of purgatory, which became increasingly farcical as it became clear that there was nothing to investigate. Is my tweet? Lawyers apply law to facts. The anti-discrimination harassment policies I was accused of violating are pretty short, pretty clear. Apply that to the facts, which are even shorter and clearer. The tweet. And it shouldn't take, assign it to the most junior member of the faculty, and 10 minutes later they'd come up with an answer. But no, it took 4 months simply because the dean did not want to have to make a decision, profile in cowardice again. And ultimately, I was reinstated on the technicality that I wasn't an employee when I tweeted. Again, this was a few days before I was due to take on the job. And so a junior associate at Wilmer Hale, one of the most prestigious, most expensive law firms in DC that was advising Georgetown, must have looked at a calendar and found what lawyers call a jurisdictional defect. But then I saw the fine print, the report I got from the Office of Institutional Diversity, Equity, and Affirmative Action, IDEA, which made clear that if ever I made such a politically incorrect faux pas again, I'd be back in the Inquisition. And that's why I decided to quit, because I couldn't do the job I was hired for, either inward facing, teaching student programs, or outward facing, advocacy, writing, and so forth. And I've been using this spotlight that I've been given, that I didn't ask for, ever since, to shine a light on the rot in academia and especially in law schools.
So most people don't want things to happen to them as happened to you, but the spotlight is really important. And so what your case, and again, it's all in the book, by the book, what
Flawless.
happened is, are you counting the number of times? Okay. Um,
But publisher
what,
gives a bonus if every interview no, I'm kidding.
okay. Okay. Um, but it gives you an opportunity to go and say that out loud to people. And I would suggest that students are intimidated, and it's even more intimidating to understand that you, with your history and your background and your public service and all the different things that you had done in the public sphere, that you could be attacked by these people. I think I'd be terrified then to be a law student who had an opinion that was out of sync with the other opinions. And so I think it's really important that you say these things and tell people these things, because we're going to get a
Right.
bunch of
I
cowards in
have
our law schools.
I have access to national media. I could publish my resignation letter in the Wall Street Journal and announce my move to the Manhattan Institute on Fox News. Most people who have cancellation campaigns run against them don't have that. And so I advise students, first of all, you don't need to be a martyr. You don't need to stand up against every injustice that you see. And you have to be strategic about things. First of all, get together in a group. There's not going to be as much activity against a group of students as against one. Second, think about both your internal outlets. You pursue recourse through the proper channels. You contact alumni. At a certain point, you might want a media campaign, and so get in touch with me, and I can put you in touch with reporters that would do the breaking news and things like that. Aaron Sibarium, for example, at the Washington Free Beacon, has been invaluable on this beat when kind of relative to what happened to me at Georgetown. There's minor kerfuffle at NYU 2 months ago when they didn't want to have me speak on October 7th. I wasn't speaking about Israel or Gaza. I was speaking about my book, actually. And they said, well, with the security concerns, we can't have you speak then, maybe the following week. And eventually, this made the national press because of a strategic decision that the Federalist Society made. And it ended up being, a much bigger deal. And NYU's president was savvier than the law school dean, because once she heard about this whole thing, she told her people to fix it, which is how within 24 hours of the national news breaking, we ended up back on NYU's campus for the actual event. And there weren't any security issues. Like, I didn't see protesters, not even on Washington Square. But anyway, that's a separate issue. So yeah, you have to be strategic about what's going on. You don't have to, take the F or the D from your professor just to make a point. No, get your good grade, but then write it up, note it, think about uh, how to make change, or how to force these amoral university leaders to respond to a different incentive matrix.
So, which raises another point. Um, Everybody responds to something. Now, we've been talking, with the exception of your personal case, about people who are going to enter the system, or maybe people who have entered the system in the last couple of years. But there is another way that judges can change the tone, change the, um, I don't know, change the outcome of the legal system. And you wrote about it as regards Judge Deborah Boardman. They can choose to apply minimal sentences to criminal activity that they don't really want to punish. Um, there was a lawyer there was a group of kids who was planning to rob a store, and they got together and they were all on a basketball team. And they were arrested because it was clear what they were doing. They were starting to rob the store, and they went to court. And their lawyer said they shouldn't be punished. Now, they were punished. That's fine. Deborah Boardman had in front of her Nicholas Roski, the guy who had plotted to kill the Supreme Court Justice Brett Kavanaugh. And she under-sentenced him. I mean, she gave him a sentence that was wildly under what he should have gotten. And you wrote about that, and you said she should be impeached. Is this something, though, that we see often, that judges determine that they don't want to punish people, so they let them go?
Um, I'm not a criminal lawyer, so I don't know. I don't have the full perspective on this, but certainly, most of these cases don't involve Supreme Court justices in assassination attempts, so they don't make national news. But there are, I think, injustices that happen in terms of sentencing. Doesn't mean that each one warrants impeachment. I'm not someone who has a long record of calling for the impeachment of judges and justices. In fact, I wrote up my call to impeach Judge Boardman in City Journal a couple of months ago, and I noted that this is the first time that I've ever said that a judge should be impeached because not just because the sentence was lenient, but because it seemed the leniency was driven by the defendants, the would-be assassins, decision to identify as a woman, throwing this into the gender identity wars, if you will. And the judge said that specifically because of the Trump administration's policies in this area regarding transgender people in prisons and all sorts of things, that was an additional reason or the main reason for downgrading the sentence. I think that's completely inappropriate that's what put this to the point of impeachment, not simply it was this perpetrator should have been sentenced to more, given a harsher penalty, but the politicized reasons for it, I think, is what goes that way. In terms of federal judges, only 15 in our history have ever been impeached, and of those, 8 were removed. So it doesn't happen very often, and all of them were for instances of personal malfeasance, corruption, things like this. Generally not, or not generally not, but simply not uh, their court rulings or their judicial acts. Um, but we're seeing rogue judges of various kinds acting for political reasons. Again, acting for corrupt reasons, not bad judgment or something like that. That's you know that happens, and that's unfortunate. And there are remedies for that that probably fall short of impeachment. But this is I think a perversion of the judicial duty, and so we need to be cognizant of that.
So the perversion was actually bringing her personal sociological or political opinions into the courtroom and using that as a standard for sentencing.
I think that's right. I think that's right. I mean, there are no standards for impeachment. High crimes and misdemeanors, um, as applied to the president, doesn't mean it's a political judgment of what makes someone unacceptable. Has done something to so besmirch the office that they should be removed. And I think Judge Boardman's conduct is doubly alarming against a backdrop of escalating political violence. The assassination of Charlie Kirk, the text that came out from the Virginia Attorney General, now elect, desiring the death of a political rival and his children, the rise in ideologically motivated intimidation on and off campus, relating to Gaza and Hamas and otherwise. We live at a time of a kind of a thin line between rhetoric and violence. And I think actions like Judge Boardman's are enable that. They say, "Oh, I can go out and it's not that big a deal. I'm not going to be thrown in jail for the rest of my life for almost killing a Supreme Court justice, let alone some a lower ranking official." So all of that in context, I would suggest makes this go beyond even just a generic case like the basketball team or whatever you're talking about, someone who lets somebody off that seems like an injustice.
So again, everything you say raises another question. Um, how do you prevent that? How do you keep, and I'm not talking about impeaching other judges. I mean, impeachment being a very specific thing and you're applying it very specifically to that judge. But a lot of judges bring their political opinions to the bench with them. And I don't remember that being the case. I mean, it seemed to me there was a time when Congress passed laws and judges applied the law to the situation. That's where you were. Now, this goes to your other book, Supreme Disorder, which I consider the precursor to the problems we have now, where you wrote about Congress's responsibility here by not passing specific laws and then allowing things to be kind of manipulated by the executive branch or decided by judges or whatever. How much trouble are we in? Because Congress doesn't pass laws, but they pass opinions. And then you get a judge's opinion on top of the opinion.
Well, it's that they either don't pass laws or they pass such broad laws that it gives power to the administrative state, the which is really part of the executive branch. We had a case argued at the Supreme Court this week about presidential authority to remove the heads of independent agencies, which seems like a slam dunk. We only have three branches of government, so any government agency has to fit into one of the branches. You can't have some free-floating, unaccountable fourth branch, and that's what the Supreme Court going to rule, but it's going to overturn a 90-year-old precedent to get there, from the New Deal, not surprisingly. Um, but the point is, because Congress has abdicated its duty to legislate, it's been um, other parts of government, whether independent agencies or cabinet departments, that have promulgated regulations that now comprise the bulk of our federal law. It doesn't matter whether it's called a regulation or a law; it still has binding effect. Congress can always overturn a regulation, but until and unless it does, that's as much of a law, including being able to throw you in jail if you violate it, as if it was an act of Congress. And you can't, you know, unelect those regulators, those bureaucrats. You can only sue them, which is why.
We've lost your audio. Um, Ilya, we've lost your audio.
um,
Oh, you're back.
I'm back.
You're back.
I'm back.
Okay.
Okay. I didn't do anything. Okay.
I don't know. I didn't say you did, but we
Okay.
lost you for about a minute. So if you would just kind of think back a minute.
Yeah. So because you can't vote out the bureaucrats and the regulators, you can only sue them. And so much focus in our public affairs has shifted to the courts because there are lawsuits when these regulations hurt someone. And so every June, the Supreme Court decides half a dozen of the most important political issues in the country. Some of those are unavoidable when it's a question of constitutional rights. But so much of it is driven by agency action and whether the agency has the power to do what it's doing, whether the agency is violating constitutional rights, that sort of thing. And that's a problem. And we've gotten to where we are more broadly in terms of the fights over judicial nominations, the Supreme Court, and everything else, because we're at the culmination of several trends where divergent interpretive theories map onto partisan identification or preference at a time when the parties are more ideologically sorted and polarized than they've been since at least the Civil War, if not ever. And so, what the party of the president who nominates in the Senate that confirms judges matters a whole lot in terms of all of these major controversies. And so the only way to depoliticize those judicial nomination processes and how we think about federal courts, isn't to change the rules or say that after a certain number of days after a nomination you have to have a vote or anything like that. or change the hearing so only the lawyers for the committee are asking questions rather than bloviating senators. That's rearranging deck chairs on the Titanic. That's a symptom of the underlying problem, which is the federalization and the centralization within the federal government of power. So the only long-term solutions are federalism and the separation of powers. That's not an easy solution. It's not a quick one. But until and unless that happens, we are stuck with this dynamic.
So when the president says, I'm going to move the Department of the Interior out to Colorado because that makes more sense, Congress doesn't want it to go there. And so they say you can't do it. Or um, he wants to withhold funding from USAID, and the Congress says, well, you can't do it. All that stuff goes to the courts. And then again, aren't you faced with the politicization of this? People who don't like the president, don't care for his mechanism for changing government, vote against it.
Well, that's an appropriate thing to get to the court. If someone's challenging, if they're, arguing that the president is doing something that's beyond his authority, or arguing that Congress passed a law that's beyond, its authority under the Constitution's the power to regulate interstate commerce under the Constitution. There's no one other than federal courts that can resolve those disputes. Um, but I'm talking about, all of our litigation over Obamacare, say.
Yeah.
I don't see how healthcare is a federal concern. Um, if you have national insurance companies, you can argue over reimbursement and standards and things like that. But if I'm going to my doctor down the street here in Falls Church, Virginia, I don't see why the federal government is regulating that relationship one way or another. Um, and there's so many areas of life in which we have federal involvement. And my favorite example of this is about 10 or 15 years ago, there was a robbery of a pizza joint, small pizza joint in a suburb of Cleveland, that ended up becoming a federal prosecution. Why? There was no, significant amount of money involved. There wasn't, a kidnapping. There wasn't, it was just, robbing a pizza shop. Well, the dough, tomato sauce, and cheese all came from out of state, which put it into federal jurisdiction. That's ridiculous. And we see that again and again in so many different areas of law. It doesn't mean that all areas of modern life should be left to the states. When you're flying, that seems like interstate commerce to me. When you're shipping something from, which happens a lot, obviously, in the modern world,
Right.
more than it did in, at the time of the founding, that's interstate commerce. That's properly a subject of regulation by the federal government. But so much is not.
I seem to recall historically, I'm not that old, that Eisenhower had trouble with the interstate highway system because there were states who said, what if we don't want to? You can't be in our state. Um,
Right, right. They're like, okay, maybe on the exact border with the other state, we'll give you like a few feet on either side, but
right.
otherwise, this is ours.
I think, that was a big one because there we had a Republican
It was
president.
ultimately justified not so much under interstate commerce, but for national defense.
Uh,
That you needed ways to move tanks. You needed, if you look at interstates, actually, every certain number of miles, there has to be a completely straight stretch. And that's to enable planes to land. So this was all part of the, National Defense Authority.
Okay. So it does seem that President Trump is looking to roll back the state, the administrative state. But on the other hand, people have gotten very accustomed to getting some things from the state. And it seems to me he's setting up the possibility of some very unhappy citizens. You know, despite the problems of Obamacare, people are moving in the thinking toward more socialized medicine. In New York, they just elected a socialist. He's going to have socialized grocery stores. If people want that stuff, and clearly they did in New York because they voted for it, is it possible to change the administrative state, or are we stuck on a road that gets more and more involved and bigger and bigger?
Well, Bernie Sanders tried to do that in Vermont when he was there, and the system collapsed. But nobody ever learns from that. Um,
I'm sorry, but nobody's
our,
ever learned from the collapse of communism either.
right.
They did try this with state grocery stores, and I remember long lines and, stuff like that. So yeah, we've seen it collapse.
I don't see what the exact issue is, why we need to have state grocery stores. If the argument is poor people don't have enough food, then increase their food stamps. If that's what you're saying, increase the money you give them to buy food if they don't have enough food. But, and then we can debate whether they actually do or don't. But anyway, um, and then there's the so-called free buses and things. Anyway,
Yeah, but if we
let,
want that stuff and we vote for that stuff, ha is that an inevitable increase
will
in,
every country ever collapse into communist autocracy? I don't think there's inevitability of that kind. As long as the economy, my friend Dan Mitchell talks about Mitchell's golden rule. As long as the economy grows faster than the government, we're okay. I'm not sure where we are on that score these days. It fluctuates. Um, but there's the administrative state, and then there's the scope of the government. So Medicare is popular, Social Security is popular. I'm not sure that a lot of federal programs enjoy that level of popularity, let alone federal regulations that make things so expensive. We talk about, Democrats especially now are talking about affordability, housing especially. Well, where is it easier to build houses where there's less regulation? So not California, not New York, not Illinois. Um, you want to make things affordable, make them abundant. That's how prices drop, right? Um, and so, we're at cross purposes there in terms of a regulatory agenda. Trump has not, he wants to drain the swamp. He does want to cut down on the administrative state in certain parts. That doesn't mean, but he said he's not touching Social Security. He's not touching Medicare. So we can certainly pick and choose. At a certain point, I think we're going to have to deal with, Social Security's coming insolvency, Medicare's inefficiency. The solution to whatever ails our healthcare system is not to throw more people on Medicare. The rest of the system, the one that's profit making, subsidizes by definition through taxes the socialized parts of it. So as Margaret Thatcher said, at a certain point you run out of other people's money. So I hope we can figure out a way to tweak certain things and escape before the house of cards comes tumbling down. But I don't know, Shoshana. If I knew, then I'd be spending all my time investing in the right stocks rather than talking to you.
that? Well, I'm glad you're talking to me. I'm sorry you're not investing in the right stocks. On the other hand, you could write another book, and that would be helpful.
Books generate some money, but they're not, even bestsellers these days. This is, I've been talking to my agent and others in the publishing world. People don't read, and people don't buy, more importantly, books anymore. Um, so that's not, but they are kind of loss leaders, professionally speaking. I get a lot of, speaking invites and things like that, and writing opportunities
Okay,
from
so
elevating the brand.
I'm going to use this as another opportunity to tell the listeners to buy the book. So you've got to buy the book, not only because it's a great book and an important book, and it is those things, but you need to buy the book.
So this
There you
is the
go. There's
book.
the
This is
book.
Lawless. This is the old books, the previous books. I've got these lights that are, I think, counterproductive here. Anyway, this is the paperback edition of my previous book, Supreme Disorder, which updates us through Ketanji Brown Jackson's confirmation.
So did she really say that the government should be run by oh, what did she call them? Experts. And
Yes, this is
yes,
her Wilsonian moment. We don't want to have a situation where the president can fire scientists, doctors, economists, and replace them with loyalists who don't know anything.
Uh,
So there are two basic errors there before we get even into the Wilsonian idea of getting rid of democracy because we should just have government of experts. One is that the experts generally aren't the heads of these agencies. She said that in the context of this argument this week in Trump v. Slaughter about the removal of a member of the Federal Trade Commission. That member, Becca Slaughter, was formerly a lawyer for Chuck Schumer. She is not a scientist, an engineer, a doctor, some sort of relevant, subject matter expert. Um, so if we're really talking about civil service reforms or politicizing that, that's a completely different discussion. Two, what was two?
I don't remember. I
I
didn't
don't
get as
remember.
far as two, but
I think I lost my train of thought. But the um, uh, uh, anyway, yes. What made her idea problematic was that it doesn't go to the constitutional question of who's in charge, because we don't have a system where even the president just appoints one person to be in charge of the healthcare system. Robert F. Kennedy, who's the Secretary of Health and Human Services, isn't just, you know, without any check dictating what policy is. I mean, we have all sorts of, at base, it's the president who's responsible to the voters. That's where the buck stops, rather than some independent agency. This came up in the argument. Could we dissolve all of the cabinet departments and just create multi-member independent agencies? We would have the Education Commission, the Energy Commission, the Health Commission, and then those people would not be responsive to the president. The Constitution simply doesn't allow that.
actually, that makes me feel better. Not that I don't like experts, I do like experts, but I do sort of think the Constitution gave us three branches of government, not 17.
Well, ultimately, there has to be a decision maker, and it's not the our system of government doesn't just say we follow experts blindly. We don't know which expert is right. There are processes like courts. You have battle of the experts, and you have competing expert witnesses, and ultimately it's the judge who makes a decision on that, or the jury. It's not just we have expert testimony and that's it. That's the end of that kind of case. So there's no Deus ex machina. Men aren't angels, in other words, to hearken to Federalist 51. We have these fallible systems of self-government, and the best we can do is make sure there are internal checks.
Okay, I want to get us back in the end to law schools in a minute, but we got a question from a listener, or at least she made a point to us. Most Americans do not realize that to get medical benefits, for example, in France, you have to work, and there are different medical plans, I guess, depending on what you do. So is it possible to create smaller changes instead of saying, let's get rid of Obamacare, to create changes like that without, severely disrupting the system? I don't know.
I think so. I think it's easier to have work requirements. We have work requirements for welfare, obviously. That was
We
put in under President Clinton,
we
and
did, and then some of them went away.
some of them went away. Trump put some of them back. Right, but anyway, it's easier to put those kinds of requirements in than to completely change the system. I think the questioner is right.
Okay. So I want to go back to the book,
Also in
Lawless.
in France, by the way, or in Canada, we've seen the most extreme version of this, I think, or in England. If you're not rationing healthcare by price, then you're going to ration it by time. In Canada, lots of people die on waiting lists for MRIs and CAT scans.
Yeah. And in England, I understand that as you get older, they are less likely to treat you, period. End of conversation.
That's
Um,
right. That's right.
because, and as I get older, I worry about that more and more. Um, so yeah, so not all those restrictions are good ones, not all of them are fair ones, but different people, different systems. Um, can't do anything about, don't want to do anything about that in a major way. To go back to where we started, which is universities and who they train and how they train them. Um, and you made excellent points in the book about what it costs to go to law school now because of all of these administrators and DEI people. You have to pay them. So all of this. You had a couple of suggestions for fixing it. And you pointed out that these were um, the four things you wanted to do. I'm sorry, I don't remember who you said you did them
with Chris
with.
Rufo.
With Chris
Yeah.
Rufo, which is another thing I want to say about the book. I love the fact that you give credit to everybody who participates in a variety of ways. Most authors are a little more self-serving and a little more. So when you read the book, everybody, which you are now all going to buy, you will see a broad range of people that Ilya credits with this or that or the other thing, which should make you read them as well. So you and Christopher Rufo, however, had four ideas for fixing things. Do you want to go through those so that we leave on sort of a happy note that there is
Well,
a,
I hope I can name them all, so I'm not left in the Rick Perry scenario from the what is it, the
oh, for heaven's
2016
sake.
debates when he couldn't identify three cabinet agencies he wanted to eliminate.
Oh, it's
Yeah,
true.
so one of them is getting rid of DEI bureaucracies, um, which in for public school, state legislatures can and have done. You can just say these offices are value subtracting centers, and we can get rid of them. It doesn't mean you know you don't have cultural programming or student life support or what have you, but this is all stuff that's grown up since I left school, and which honestly, Shoshana, sometimes it feels like just yesterday that I was in college and law school, and sometimes it feels like it was on a long time ago on a planet far, far away.
Yeah.
But anyway, so get rid of those bureaucracies. Number two, get rid of identity-based preferences for admissions and hiring. Now, the Supreme Court ruling a few years ago against Harvard and UNC talked about racial preferences for admissions, but this goes more broadly. Other kinds of identity preferences, and also for hiring, for contracting, all of these sorts of things. Um, Getting rid of uh, ideological litmus tests, diversity statements for hiring and admissions. My colleague, who's now been my colleague for, I guess, over a year, John Saylor at the Manhattan Institute, has been an investigative reporter for a long time. And he started using FOIA, Freedom of Information Act requests to get hiring documents from public schools around the country. And then he writes an op-ed about one of them. The first time, I think, was like 4 years ago. He found that Texas Tech was using diversity statements to hire biologists, economists, you name it. And this came out in an op-ed in the Wall Street Journal, and the next day the chancellor said, "No, we're not gonna do this anymore. This is inappropriate." So you kind of name and shame in that way, but certainly you shouldn't be hiring people based on something other than their expertise in that given area. And the fourth one, uh-oh, here we go. What's the fourth one? Do you have it in front of you?
I don't have it in front of me, but I'll give you a minute to think about it. And I will simply point out that my son, who was a professor of ancient law, mostly Egyptian and Greek, was asked to sign a statement at a particular large university to get a tenure track job. And he declined. And he declined the job. And he is now tenured at Vanderbilt University, which doesn't have any such thing. So part of it is free choice. If you choose not to do something, maybe part of the answer is that we as citizens need to choose things that work for us and maybe not send our kids to that particular school that requires you to sign a pledge of obedience and go to the other places.
Right,
I
right. So
understand there's big movement to Southern universities.
there is. It's quite impressive. I call it the dynamic of the cold and the scolds, where people flee inhospitable climates, both ideological and meteorological. So applications to ACC and SEC schools are way up, and a lot of those schools are creating new centers and institutes within them for classical education, for classics education, for civics, all of these different things, and those are good developments. The fourth item that I had missed was ending mandatory trainings of various kinds, diversity and all the rest of it. Um, you work for the JPC, which hopefully doesn't have any of this kind of nonsense, but
No.
Manhattan Institute is governed by New York law, and so every year we have to click through this sexual harassment, other kind of workplace training stuff. Our VP for our COO has picked the most innocuous of that brand that he can find, but it's still kind of ridiculous stuff. And there's no evidence that all of these kinds of trainings on so-called unconscious bias and whatnot have improved cultures or made people workplaces more welcoming to racial minorities or whatever other metrics you're measuring. In the campus context, there have been surveys that have showed that there's an inverse correlation between the
Right.
size or budgets of DEI offices and the student sense of belonging or comfort with diversity, racial or otherwise. So that's why I say that these are value subtracting structures.
We're getting close to wrapping up here. In fact, before we do, I ask you something else. So you mentioned the campus atmosphere and the group that we, not just we as the Jewish Policy Center, but a lot of people are focused on right now is Jews and how Jews are comfortable or not comfortable on college campuses. And a number of universities have taken steps in this direction, and the president has said things. And, you know, are administrators working to the end of making Jewish students more comfortable? I don't see
Mm.
any particular um, change. And I
It's
will say again, my son at Vanderbilt finds the atmosphere fine. Um, I talked to Coach Pearl, Bruce Pearl at Auburn, who says, Auburn is great because it is happy with him when he posts his pro-Israel stuff. Are the
you have to
universities taking?
go institution by institution. You
uh
can't generalize. We saw after October 7th a very live experiment of different kinds of leadership. Um, Take, say, Columbia at one end and University of Florida or Vanderbilt at the other. Vanderbilt, their chancellor Daniel Diermeier, uh, kicked out and had expelled students that took over his office, assaulted security personnel, and all the rest of it.
Right.
It seems like an obvious thing to do. It's a very low bar to get national plaudits, but relative to other university presidents, that gains acclaim. Or Ben Sass, in his short-lived tenure at the head of Florida, not only enforced the rules against disrupting educational programs, but he had some creative solutions like to deal with the encampments, like turning the sprinklers on, for example.
Right.
So, there's in so many places, these are not intractable problems. How to make it a better culture for Jewish students, or more broadly, just how to return institutions to respectability. Um, there are going to be savvy administrators, and not because they're on the right, just because they're better at their jobs and they're not blinded in echo chambers, and they care about the core educational mission that are going to be better than others. I'll give you an example from before the current time. Elena Kagan, now Justice Kagan, was once dean of Harvard Law School 25 years ago, and less than 25 years ago. Because when I was graduating college and looking at law schools, I had friends tell me, don't go to Harvard. It's miserable there and it's, ideologically crappy. And that's a term of art. Go to Chicago, go to other places. Um, and Elena Kagan turned that around, at least somewhat, at least during her tenure, bringing in professors with different viewpoints, creating a better experience for students, welcoming the Federalist Society. She spoke at one of the Federalist Society's banquets, and she
Wow.
said, "I'm glad you're here. I'm very glad you're here. You are not my people, but you add so much to this community." And so there's a way to do this. It's not simply, pick one side or the other. The role of higher ed is not activism or indoctrination of any stripe.
So that's a great place to stop, and we're going to stop. If you had to choose, would you say you're optimistic about the future or pessimistic? And those are binary choices. You don't get to blend them together.
I'm not going to fight the binary, but I'm going to play semantic games. I'm going to say that
Okay.
I'm less pessimistic than I was when I left Georgetown 3.5 years ago. But it is going to be, there are going to be differences institution by institution.
Mhm.
And we're seeing that already in terms, of comparable schools in the last 10 years, the reputation of University of Florida versus University of Michigan has changed just dramatically. Um, and there are examples like that across the board. And you're going to have, some schools' reputations go up, some go down, some be known as places that are hospitable for someone who actually wants an education. Some that are just, diploma mills or finishing schools, and employers are going to start reacting to that as well. So we're certainly in the eye of the storm and in a period of flux, and it's hard to make generalizations.
So I'll take that as a semi-optimistic possibility and say that clearly what you've just said is the onus is on us as the people who attend those institutions or send our kids to those institutions. And that's not a bad thing either, because that puts a lot of power in the hands of the people, which I always think is a good idea.
Absolutely, absolutely. You asked at the beginning when you were giving my bio, my attitude towards my alma maters is very different. University of Chicago versus Princeton. And my wife and I have 4 kids. The oldest is about to turn 10, so we do
Wow.
have some time before these decisions will be made. And I think the constellation of choices will look different then, I hope, than they do now. And I think they'll look radically different than when I was applying to college.
Well, I hope you'll come back and discuss it with us. I hope you'll come back before that. But when you get to that point, let's talk about it. Ilya Shapiro, thank you for a wide-ranging and very important, very enlightening program. Thank you very much.
Thank you. And I don't have a mac and cheese recipe. What we run is a contest, and I'm the MC for that.
Because you're not cooking.
I
Okay.
don't think people would want me to. I make the turkey for the actual Thanksgiving meal, and I spatchcock it. I'm a big evangelizer of
Ah,
flattening, spatchcocking
eh.
the turkey so that the white and dark meat, you have a problem. One's too dry, one's too wet, undercooked, whatever. No, this solves that.
Okay, here's my promise to our listeners. I will have Ilya back. If not before that, I'll have him back before Thanksgiving. He can discuss the ups and downs of spatchcocking, but also what makes the best macaroni and cheese recipe. Thank you.